Welcome to Singapore Property Talk Law. Today we're diving into a rather, well, unusual property case right here in Singapore. It's a story that really makes you think about, what you're actually buying when you invest in property. It involves a beauty salon owner and a surprising twist on size.
That's right. We're looking at the case of Madame Pan Ying. She purchased a commercial unit at the Dunedin condominium. Now, the initial understanding, what everyone thought, was that the unit was 818 square feet. That figure was on property portals. Even the official title search showed it.
Okay, 818 square feet.
But the actual usable floor area turned out to be only 619 square feet.
Wow, hold on. That's nearly 200 square feet less. A huge difference.
Exactly. A really significant gap.
Okay, let's unpack this because how could such a discrepancy even exist? That sounds fundamentally wrong.
Well, what's fascinating here is the technicality behind it. It
Mhm.
comes down to how certain properties are measured. For properties with sloping walls, like this particular unit Madame Pan bought, the official lot size is calculated based on the larger of either the ceiling area or the floor area.
The larger. Okay, that's counterintuitive.
It can be. They give it like maybe an upside-down funnel or a vase that's wider at the top than the bottom.
Hmm.
The official measurement might take that widest point,
Yeah.
the ceiling in this case, even though the actual space you can stand on, the usable floor, is smaller.
Okay. And Madame Pan's unit had this specific shape, you called it an inverse trapezoid?
Correct, an inverse trapezoidal configuration. So the ceiling was actually bigger than the floor. That bigger ceiling area generated the 818 square figure you see on paper, but the floor space you could actually use was considerably less.
Right. It really highlights that the headline figure, the number you see first, doesn't always tell the whole story about usability.
Absolutely. And for Madame Pan, this wasn't just some minor detail. She had plans. She was counting on that larger space to expand her beauty salon business. Finding out the usable space was so much smaller, really, threw a wrench in her plans.
I can only imagine. Suddenly your expansion plans are maybe impossible in that space.
Exactly. It forced her to consider operating from two separate locations instead, which is obviously not ideal. You can imagine the frustration, the cost implications.
Absolutely. So naturally, she felt misled and decided to take legal action. She sued her agent, Jasmine Zhu, and the agency ERA Realty Network.
Yes, she sought over $590,000 in damages, claiming misrepresentation of the usable floor area.
Now, it's important here, the agent didn't just invent that 818 square foot number, did she? Where did it come from on her end?
No, and this is where the case gets quite interesting legally.
Oh.
The High Court actually looked into this very carefully. They found that the agent, Jasmine Zhu, had actually performed typical due diligence for a property agent in Singapore. She had cross-referenced the information the vendor gave her with property portals like EdgeProp. These portals also listed the unit as 818 square feet, based on the official records from, like, the title search.
So she did the standard checks.
Pretty much, yes. The court's assessment was quite nuanced. They didn't find evidence of direct misrepresentation by the agent. Instead, the judge sort of suggested that both the buyer, Madame Pan, and her agent were, in a way, jointly misled.
Jointly misled.
By whom? Likely by the way the property was initially marketed, possibly going back to the developer, focusing on that larger official strata area figure without clearly highlighting the usable floor space difference caused by the unique shape.
Okay, so the court acknowledged the agent did her checks and both were misled. But what was the final legal outcome for the agent and ERA?
Well, ultimately, the High Court dismissed Madame Pan's lawsuit against her agent and ERA.
Dismissed it. Why, if they were both misled?
The judge's reasoning really centered on the sheer novelty of the situation. How often do you see an inverse trapezoid commercial unit where the ceiling is significantly larger than the floor? This specific scenario, the unusual shape combined with a specific measurement rule for sloping walls, was deemed so uncommon.
So rare.
Exactly. So rare that a reasonably conscientious agent wouldn't typically be expected to know about it or specifically look for it during the usual course of property transactions in Singapore. It wasn't standard knowledge or practice.
Interesting. Was there evidence to back that up?
Yes, quite strongly. A joint expert witness, a seasoned real estate professional named Taika Po, actually testified. He stated he had never encountered such a situation in his entire career.
Never. Wow.
Yeah. So the court saw it as a genuine blind spot. Not negligence, but something truly outside the norm that standard training wouldn't cover.
So what's the big takeaway here then, for people listening, maybe looking at property themselves?
I think this case really, really underscores the need for vigilance. And that applies to both buyers and agents. especially when you're dealing with properties that have unique architectural features or anything out of the ordinary.
Don't just trust the headline number.
Precisely. It highlights a potential gap in how property sizes are sometimes understood and represented. The official strata lot size is one thing, but the actual usable space might be different, particularly in these unusual cases. It really prompts the question, beyond the stated square footage, what are you actually getting in terms of usable area? You might need to dig a bit deeper.
Let's go back to Madame Pan's specific argument. She focused on the misrepresentation of usable floor area, right? What did the court think about that specific claim?
The court looked at the evidence supporting the claim that the agent had specifically represented 818 Sal TA as usable floor area. They found that the written documents supporting this claim were a bit vague, not sufficiently clear or definitive to prove that specific misrepresentation.
And what about communication between them?
Interestingly, text messages were brought up. They apparently suggested more of a shared misunderstanding initially. Like, both were operating under the assumption that the official 818 Scoutum figure was the relevant size, without necessarily distinguishing usable floor area at first.
And the timeline was also relevant, wasn't it? When did she actually discover the discrepancy?
Yes, that played a role. She bought the unit in early 2020. But the size issue only really came to light during interior design measurements in late 2021. What's more, she had actually been operating a salon in the same building since 2015. So the delay in noticing the specific size issue of this unit was factored into the court's assessment of how and when the misunderstanding truly arose.
Right, that context matters. And wasn't the lawsuit originally broader, involving more parties?
It was, yes. Initially, Madame Pan's lawsuit involved 5 parties. The case against the vendor firm itself was discontinued because the company had been struck off the register. And there was a confidential settlement reached separately with the vendor's agent and their agency. But the key judgment we're discussing here, the one that went through the high court trial, focused specifically on the outcome concerning Madame Pan's own agent and ERA.
Got it. So, wrapping it up, the judge's final word really seemed to emphasize just how unexpected this whole situation was.
Exactly. The judge essentially concluded that this was such an unusual, almost unique set of circumstances. Everyone involved, buyer, agent, was sort of caught unaware by this specific technicality related to this specific unit shape. And in that context, there was little a diligent agent could reasonably have been expected to do differently to foresee this specific problem.
This case, as we've explored here on Singapore Property Talk Law, really serves as a crucial reminder then. When it comes to property, even something seemingly straightforward like size can have these hidden complexities.
Definitely. That distinction between the official stated lot size and the actual usable floor area, especially as we saw in properties with unique designs, is something you might really want to consider carefully in your property journey.
It just encourages a deeper level of scrutiny, doesn't it? Looking beyond just the numbers you see on a listing.
A very healthy dose of scrutiny, yes.
Yeah.
Ask questions, perhaps even get your own measurements done early if the layout seems unusual.
Good advice. Well, if you found this deep dive into the intricacies of property measurement insightful, make sure to like this and subscribe to the channel. That way you won't miss our latest explorations of the Singapore property landscape.